How is it that we find ourselves surrounded by such complexity, such elegance?
The genes of you and me, the genes of you and me, are all made of DNA. We're all made of the same chemical DNA. We're all made of DNA. We're all made of the same.
Hi, you're listening to DNA Today, a podcast and radio show where we discover new advances in the world of genetics. From genetic technology like CRISPR to rare diseases to new research, we have you covered. For a decade, DNA Today has brought you the voices of leaders in genetics. I'm Keira Deneen. I'm a certified genetic counselor and your host. TrackGene has designed a genetics electronic health record. Here's what it features: pedigrees, demographic data, genetics information, risk tools, and sophisticated reporting, all within a clinician-designed workflow. It integrates with other clinical genetic software, databases, and hospital information systems to maintain accurate patient records. Go check it out at trakgene.com. Again, that's TrackGene without the C.com. And be sure to check out episodes 208 and 210 of DNA Today, which features TrackGene. I'm very excited to introduce our guest for this episode, Jorge Contreras, who earned his law degree from Harvard and teaches intellectual property, science policy, antitrust law, and genetic law at the University of Utah. He authored this awesome book. If you guys are watching the video on YouTube, I'm holding it up, The Genome Defense. In this riveting behind-the-scenes courtroom drama, a brilliant legal team battles corporate greed and government overreach for the fundamental rights to control our genes. Thank you so much for joining me, Jorge. This is really exciting because I've been reading your book for, about a week and a half now. So I've just been reading your words and just very focused on them. And now I'm actually talking to you.
No, well, thanks. It's a pleasure to be here. Thanks so much for inviting me.
Yeah. And there's just so many key genetic players that played a role in this story that is now almost 10 years old. I mean, your book came out a year ago, so you just hit the anniversary. So congratulations on your first anniversary of the book being out. And, we're going to hit 10 years next June, in June 2023 of this court case. But, I'm kind of skipping ahead. So why don't I, rewind a little bit? And obviously we're talking about the court case where the Supreme Court heard, should genes be able to be patented? That was really the core question that it came down to. But I want to rewind all the way back to, why did the ACLU feel so strongly that gene patents should be banned? I mean, that's really, I think, where the beginning of the story is. What is your perspective on this? I mean, you interviewed a lot of people to be able to write this book. It was like nearly 100 people.
Yeah, absolutely. And everybody had a slightly different perspective, right? But, the long and the short of it is the principal ACLU lawyer, Chris Hansen, who led the litigation team here, just couldn't believe that it was possible to patent human genes. He had no background in patenting, really had never tried a patent case before, never took patent law in law school, but had some idea about ownership and intellectual property. And when he heard from Tanya Simoncelli, who was the ACLU's science advisor, that this was happening and that genes had been patented for at least 20 years in the United States, that it was basically black letter law, supported by the U.S. Patent and Trademark Office, he just couldn't believe it. And it seemed to him fundamentally illogical and fundamentally wrong that a company or an institution could own something that was essentially produced inside the human body. It wasn't invented by that entity. So there was just a fundamental disconnect between the practice and, logic seen from somebody who was an outsider.
Yeah, I mean, I certainly learned about it after the fact because I was graduating high school when this was all happening. So I learned about it as I got into undergrad and I was like, oh, that happened. But I mean, as you said, the patent office had been issuing gene patents for 20, 30 years. And in the book you quoted, in 2005, MIT estimated that 20% of known genes, so like 4,300 genes, were covered to some degree by patent claims. So this wasn't just like a couple patents we're talking about. I mean, this was years worth of patents happening that suddenly ACLU was like, I don't know if this should be allowed, and really kicked off the whole story that, ends up happening. And you raised some great points in the book that I didn't even think of until you said it. And I'm like, why didn't I think of that before? Of course. And one of those is that gene patents could inhibit whole genome sequencing, which makes sense when you say it. But I was thinking, okay, gene by gene, because that's what we were doing at this time, back in, we're talking 2010, 2013, kind of that time zone. And it's just wild that gene patents, like the effect that they had, in order for the ACLU to pursue having these court cases and trying to ban gene patents, they had to figure out one company to sue, because you can't just go to the court and say this should happen. What led to choosing Myriad? I mean, specifically the BRCA related gene patents, because there were other contenders. I mean, there was a company that I learned of from your book called DNA Sciences that had a patent for genetic testing for a condition called long QT syndrome, and they had the patent, so nobody else could be offering this testing, but they were offering a test. So to me, I'm like, dang, that would have been like an easy one to do. I mean, there was a 2-year hiatus where Americans, people in the U.S., couldn't get testing because they had the patent, no one else could do it, and they weren't offering it. So I'm like shocked that even happened. But eventually, they didn't choose DNA Sciences. Most people probably haven't heard of them. They chose Myriad. So what were the main factors you think that went into that decision? Yeah,
absolutely. So, the ACLU changed its policy by bringing litigation, right? And you're absolutely right. To bring litigation, you have to sue somebody. You're not going to Congress saying we should change this law, that should affect everybody very generally. You've got to pick a defendant. And there were thousands of gene patents. The patent that you mentioned, which covered the LQX genes, it was bad, right? This company went into bankruptcy, and so it wasn't performing testing for 2 years. And this is long QT syndrome is a cardiac arrhythmia that's treatable with beta blockers, but which, if you don't identify the mutations in a pediatric patient, you're not going to give them beta blockers. And children were dying. And so many of the people involved in the case thought, what more sympathetic case could you have than a case where children are dying? And that's true. It's extremely tragic what happened with long QT. But Chris Hansen and some of the leadership at the ACLU decided, no, this is a tragic story. But in order for this case to really succeed, we need to pick something that everyone has heard of, that will get real public support for. And breast cancer just leapt off the page at them. Breast cancer is probably the disease in the United States that has the most advocacy behind it, the most fundraising, the most public awareness. I would bet that virtually everyone in the United States has been affected in some way by breast cancer, either as a victim, patient, or knowing someone in your family or a close friend who has had it. And so it affects everyone, and it really resonates with the American public. And they tried to tap into that. And conveniently, there was a company that had numerous patents on the BRCA genes that related to breast and ovarian cancer. And that's how they got their defendant.
Yeah, and it made sense because, as you're saying, 1 in 8 females will develop breast cancer in their life. And so, statistically, you've been affected by breast cancer. And there's so much awareness around it. Like you said, people in October, it's Breast Cancer Awareness Month. Everybody pulls their pink shirt out. Specifically, I wore a pink shirt for this. I had to choose a color. And I was like, wow, it's got to be pink for this episode. So it just, I can see where that part made sense. The part that doesn't make sense to me is that the patents were only going to be active for a few more years. So most of them were set to expire between 2015 and 2018. And at the time where they were having these discussions, I say 2010 probably, because if the Supreme Court case happened 2013, maybe it was a few years before that.
It was before that. They started. They started to plan this case in 2005, and
I'm way off. Yeah, there you go.
They filed suit in 2009. Right. So Myriad's patents still had a number of years left on them.
Okay.
But But it didn't matter, right? They weren't out to get Myriad. This was a case where they wanted to change the law, broadly speaking. And so if they got Myriad's patents invalidated because the court ruled they were ineligible, that wouldn't just affect Myriad, that affects every gene patent in the country. So the long QT syndrome patent, those are gone also. And cystic fibrosis, Tay-Sachs, you name it, every one is gone. So the fact that Myriad's patents didn't have that long left on them didn't matter all that much.
Yeah, that's definitely a very important point that I think before I read the book, I was like, what was the reason behind that? And then you made it super clear in the book, and I was like, oh, that makes sense now. So it's because you're such a great writer. I feel like I know so much more about law now. It's fantastic. But anyway, I digress. So a major concern for if this happened, if patents on genes were banned, a huge argument was that it's going to destroy the biotech industry. There's going to be a huge impact on the economy, public health. I mean, what was the prediction there? What were those worries in terms of like the what ifs?
Yeah, this was a big unknown, and it made a lot of people nervous, including a number of people at the ACLU. They really wrestled with the question, should we bring this lawsuit? And I mentioned in the book what the head of litigation at the ACLU, it took a while to convince him that this case was a good idea.
He didn't sign off right away. Yeah.
No, he needed a lot of convincing. And, that's because none of them are scientists except one, right? And she's not a lawyer. And they're hearing from all of these different people in the industry, the lobbyists, the industry groups, that no, you've going against patents, that's terrible. You need patents. And, I actually agree with this to some degree, right? Patents, you do need some sort of market exclusivity to recoup very big R&D costs to make drugs and vaccines and so forth. And so the ACLU, though, they did eventually come around to bring this case, of course. They convinced themselves that we're not trying to eliminate all patents in the biotech sector, right? There's still a lot of stuff that can be patented. It's just this very first stage, this sort of research basis, the naturally occurring DNA sequence, that shouldn't be patentable because you didn't invent it. The way the patent office looked at this, they said, well, you invented it because you took that gene out of the chromosome. Chromosome whatever X has like 1,000, 1,500 genes scattered along its length somewhere. You isolated one gene and you removed it from the chromosome, and that isolated gene, in theory, doesn't exist in nature. It's something that only exists in the laboratory. So you did invent it. You actually did invent something. You invented an isolated gene. That, as the lower court judge said, that's a lawyer's argument, not a scientist's argument.
Yeah, and there was this concept that you're talking about here where there was this talk of cDNA, complementary DNA, which is what you're talking about, when you are isolating it, versus genomic DNA when it's still in the genome. And that major difference between them is that cDNA, the isolated, doesn't include the intron. So in our genome, we have lots of what we used to call junk DNA, but now we know has other roles, but it doesn't necessarily write the proteins that our body needs. So that was a major difference, but it definitely was confusing, and you could tell even the lawyers were confused at some points, and the judges were confused. I mean, was this a good argument? Because there was a really big, and I don't know if I'm going to say this word right, amicus briefing. Did I get it? Yeah?
Yep.
Nice. So that really kind of changed everybody's opinion. So can you explain that a little bit? Like, Eric Lander's kind of like really influential amicus briefing and how that worked and played out?
Yeah. So, and just to take a step back to explain what an amicus brief is. So,
yes, please do.
In a lawsuit, you've got plaintiffs, right? They're the ones who are injured, they're bringing the case, and then you've got defendants, they're the people you're suing. But if it's an important case, anyone, members of the public who have an interest in the outcome of the case, can file a brief with the court to say why they think the case should come out one way or another. And, if you're just some crackpot, sitting in your living room thinking, I hate this case, I hate the government, the court's not going to accept your amicus brief. But, often you get experts, you get industry associations, so the American Medical Association, the American College of Medical Genetics, all of these groups write amicus briefs in important cases, sort of presenting some facts and presenting their views of the case to help the courts. And amicus, it's Latin, it means friend, right? They're friends of the court. They're doing this to help the court out. And so the Myriad case attracted a lot of attention in the biotech industry, the genetics field, in patent law. A lot of amicus, 50 or more amicus briefs were filed at the Supreme Court. And I signed on to one of these briefs myself.
Wow. And is that considered a lot for a case? Like, I don't have a sense of, like, if that's not a lot or a ton or very average.
It's a lot.
Okay.
Certainly for a patent case.
Yeah.
Some of the really big civil rights cases, the wedding cake case and so forth. Dobbs, of course, the abortion case, they'll get about that. I mean, generally 50 to 100 is a lot of amicus briefs. They don't generally get more than that. So anybody can do this. So Eric Lander, who at the time was the director of the Broad Institute, obviously very prominent geneticist, and also has been involved in the legal system in all sorts of different ways. He's reading the appeals court's opinion, where the appeals court says, these isolated genes do not occur in nature. And Lander reads that and says, wait a second. Like, I just went to a talk earlier today where somebody was talking about, like, isolated free-floating DNA in the bloodstream as a result of some disease. And I forget the name of the disease. But there's some disease condition where it causes DNA to break up and float around in the bloodstream. He said...
We even see that with cancer. Yeah.
Oh, yeah. I mean, right.
Yeah,
so we're learning more and more about this.
Now that's common knowledge. Yeah. 15 years ago, not so much.
2012 or so when he figured this out. And he said, I'm going to write an amicus brief to the Supreme Court and tell them this. And he teams up with a professor from Harvard who runs their health law center and submits this brief to the Supreme Court. And like a really amazing thing happened, right? The justices really latched on to Lander's brief, especially Justice Breyer. There's a lot of gossip about this, right? Lander and Justice Breyer and Justice Kagan, like, they all live like right on Brattle Street. They're all in the same
I was going to say, in the book, you were like, they're neighbors. And I'm like, is that a conflict of interest? Like, how does that work? It's crazy.
No, it's not a conflict of interest, even though people kind of raise their eyebrows. But everyone said, like, nothing improper happened here. But out of all of the amicus briefs that get filed, it's extremely rare that the justices will ask about an amicus brief from the bench. The parties, they only get 25 or 30 minutes to make their entire argument and to spend, and the briefs, like the parties' briefs are 50, 75 pages long. To spend a lot of time on the amicus brief is really unusual. And Breyer really grilled the lawyer for Myriad about this question about whether or not...
It was like back and forth with all these analogies, like...
Yeah. The oral arguments are really something. And for those who don't know, first of all, if you're in Washington, D.C., going to an argument at the Supreme Court, it's one of the best free shows in Washington, right? You're entitled to, as I say, everyone can go listen to the Supreme Court. It's great. Some of the cases are more interesting than others. This one was a crazy argument, and the recordings are all available. If you ever want
I have to check
listen
these out now. Oh my gosh. I was like, all I'm going to get is just, what you've written in the book, which is great, but I'm like, I want everything. I want the receipts.
To hear the tone of voice, to hear how annoyed Justice Breyer is getting. And the justices, again, like, none of them are scientists, right? They're struggling to understand what in the world this case is about. And so they come up with metaphors, right? You mentioned the analogies, these crazy metaphors like what is patenting a gene like? Is it like patenting a kidney? Is it like you saw a branch off a tree and you're trying to patent that? Or do you carve that branch into a baseball bat and then you try to patent it? Or is it like a leaf from a tree? Or Justice Alito came up with the craziest one of all. There's a branch from a tree, it falls into the ocean, and like the motion of the waves then naturally carve it into a baseball bat.
Right, you're not being creative in the moment. Like, this was all in the case, every single one that you mentioned.
Yeah, exactly. These are all, and like, but a lot of these were sort of spontaneous questions that the justices asked. Justice Sotomayor is like asking, isn't this like baking a chocolate chip cookie? And I mean, to give them credit, the lawyers, like, arguing in front of the Supreme Court is extremely stressful, extremely difficult, and responding to all of these crazy off-the-wall analogies on this for the moment it's a great show.
Yeah. I mean, just from reading it, like, certainly. And what I was so surprised by is so much focus on this isolating the DNA and if that part is patentable. But they're not even using that in the diagnostic process. So did it even matter in the end? Like, they spent so much time on that. But really what Myriad was trying to do is have a patent and keep those multiple patents so that they could be the only ones doing the diagnostic genetic testing. But I don't know. So I feel like that's the part where I'm still a little bit like, why did they spend so much time on that part of the case when did that really make a clinical difference?
Right. So Myriad's patent claims are very broad, right? And the way patent lawyers work, they doing their job, they will try to claim as much as they possibly can think of when they write your patent application. So a genetic diagnostic company like Myriad, certainly in the late 90s and the early 2000s, right, when they were getting their business going, they isolated the BRCA genes, they cloned it, a billion times, and then they sequenced that from patients. They isolated the gene. They did not make a cDNA construct, right, with the coding regions and just taking out all of the coding nucleotides and stringing them together, sort of like an RNA transcript would be, right? You don't need that. You don't do that with diagnostics. Like, why is that? I mean, because deleterious mutations can occur in the introns as well as the exons, right? It doesn't matter. A shift mutation or a deletion can occur anywhere. So Myriad is not making cDNA constructs. It's not necessary. But because Myriad was able to patent the genes themselves as what we call compositions of matter, every possible use of the gene is theirs. Not just diagnostics, also therapeutics. And the real money is in drugs, right? Not diagnostic tests. I mean, Myriad make like hundreds of millions of dollars, but drugs make billions of dollars, especially if you can make a new cancer agent, right? And so Myriad got the patent. It covers drugs as well as diagnostics. It licensed all of the drug-related rights to Eli Lilly, right? Eli Lilly paid Myriad like $3 million at the very beginning of its existence, before they even found the gene, to sort of pre-reserve those rights. That's one of the reasons Myriad won the race to sequence the gene, because they had more sequencers. Lilly was helping them out with their own banks of sequencers in Indianapolis, and they were really able to surpass the sequencing, brute force sequencing capability of all the other academic labs that were in this race. And it's because Myriad's patents were so broad that they claimed things that Myriad itself would never use as a diagnostics company.
So they were just really like CYA lawyers and just like cover everything that you possibly can. It was just surprising that they ended up spending so much time in the case about that part, because in terms of me being in the genetic world, I'm like, I don't care as much about that part because it doesn't affect genetic testing. But like you're saying, the money's in pharmaceuticals, and certainly patents around pharmaceuticals are important in the sense of companies, potentially waste so much money on research and development. So they need to recoup that cost in having patents and everything. So I think patents, to me, make very much sense, like you said at the beginning, in that pharmaceutical concept and area. Have you heard of TrackGene? TrackGene is a clinical genetic software solution used by over 1,000 genetic experts around the world. You can customize the front page so it's streamlined to your specific workflow. The intuitive patient information entry page makes data entry efficient and user-friendly. Pedigrees are also easy to draw and document. Here's another vital feature. It supports HL7 integration to be used with other clinical genetic software, databases, and hospital information systems. So you can build custom reports with the simple drag and drop report builder. This has an interface with data visualization tools such as those from Microsoft to make it easy workflow. And there's more features on the way, all designed with you in mind as the genetics expert. TrackGene has an experienced team who's been working in the clinical genetic industry for, get this, over 15 years. You can request a demo for free. Go to trackgene.com. Again, that's TRAK gene, so track without the C.com. And be sure to check out episodes 208 and 210 of DNA Today, which features TrackGene. Looking at, as we said, it's been 10 years now. Do you think there's been any big negative consequences to the biotech industry for having these gene patents? Or were all the worries, not that we shouldn't have had them, but, was any of the worries, did that end up happening in these last 9.5 years?
No, I don't think it caused problems. I mean, what you will hear is that it's certainly harder for a new genetic diagnostic testing company to raise venture capital funding and make a business, which I completely accept. Of course, that's true because they can't, monopolize a market for a single test like Myriad and many other companies did with genetic tests. But that's okay, right? It doesn't matter that these companies are not forming because the tests are still being performed. Big, laboratory testing companies, LabCorp, Ambry, and so forth, they'll do these tests. And in fact, today, you can just, with your 23andMe $125, test that you mail away for, they'll test you for the principal BRCA mutations. So I'm not aware of any genetic diagnostic testing that's not being done as a result of this. It's just being done at a lower cost and without a company springing up to capitalize on every single test. They're just being done by large testing companies. Yeah, no, that's a very good point. I don't see a lot of repercussions in a negative sense from that happening. To me, it's just common sense. There was a time that we patent genes. To me, that's just crazy, because I'm seeing it from this perspective of once everything already happened. Just coming from someone that knows so much about genetic law and you're so up to date on what's happening in the field, are there any current legislation cases that we should keep our eye out for? I mean, I don't think there's anything, this level right now, but is there anything that you think that, our listeners and myself should be aware of, or anything that you predict might be coming down the pipeline? Absolutely. So there is very relevant legislation that's brewing in congressional committees right now. So ever since 2013, the diagnostics industry has not been happy with these cases and has lobbied Congress to try to change the law, right? So the Supreme Court interprets the law. It's the highest court in the land. It interprets the law. The Patent Act is a statute, passed by Congress starting in 1790. And it's been around for a long time. But Congress can change it. If Congress doesn't like what the Supreme Court decided, Congress can just change the law, as long as they're not doing something unconstitutional, right? And this doesn't get into that realm. And so there have been sort of continual efforts to have Congress pass a law that would reverse this and other Supreme Court cases around what can and can't be patented. In 2019, Senator Tom Tillis from North Carolina introduced a bill that effectively would have just reversed the Myriad decision completely, so that isolated DNA sequences, again, could be patented. There was big opposition. The ACLU and medical associations, genetic counselors opposed it, and then at the end of 2019, we got COVID-19, and it kind of fizzled out. We had a lot more public health issues that were on the front burner at that point.
Yeah, we had to sequence like COVID-19
Yeah,
vaccines.
yeah. Oh,
and, like we had
yeah.
bigger issues to deal with.
But I'll get to COVID-19. But this year, 2022, that legislation is back, and it would just effectively reverse the Myriad decision, and again say that isolated, purified DNA sequences could be patented.
Do you think there's a chance that would really pass?
Well, I mean, it might. You never know. Congress is a
Yeah.
weird thing, and this bill has a lot of other stuff in it. I mean, that's the problem.
Okay,
It's
it might be
full
buried
of-
in there.
It's yes, and I'll be the first to admit the patent law it could use some help in a lot of ways. Okay.
Yeah.
This is buried in there, and it's a problem. Why is that? The human genome has been sequenced, right, starting in 2001. Drafts of the human genome have been released on GenBank, and like this 2021, it was finally completed. Like the last genes were finally.
I think it was earlier this year, because we had Eric Green, who was featured in your book and stuff on the show, and the other leaders of the project and everything. Yeah, like that was a big deal.
Yeah, and so clearly the wild type human genome cannot be patented anymore because it's out in the public domain. But what could be patented if this law passed? Well, new variants, right? Variants that were unknown, the significance of which is just discovered. So COVID resistance, right? So maybe there's some genetic basis to COVID resistance. Who knows? Like, I've never gotten COVID. I've traveled all around, lots of airports, lots of airplanes, lots of conferences. I mean, knock on wood.
Yes,
I've been vaccinated, I've been boosted, all that stuff. But I've not gotten it. Maybe there's some genetic feature to that.
But if there is, and let's say you have that and it's in your genes, wouldn't you own that and not if I was your geneticist and I was taking a sample from you and figuring it out? I don't know. That still feels weird to me.
That's right. And so from 2013, the answer is no, they couldn't patent that. But if this case is reversed, then if it's new and it is quote unquote discovered or invented by someone, then maybe. More important are non-human genomes, right? Pathogenic genomes. So the RNA sequence of SARS-CoV-2, for example, it's short. It's 30 kilobases long, right?
That is pretty
was
short.
sequenced. It's got 4 genes, right? It was sequenced rapidly by scientists in China when the outbreak emerged. They immediately posted it to GenBank, and researchers around the world were able to jump on it and start to develop diagnostics, try to understand its biology, and eventually we got vaccines pretty quickly. That wasn't the case with prior outbreaks. If you look back at SARS, if you look at H5N1 influenza, MERS, the Middle East Respiratory Syndrome, in all of those cases, there were the first research institutes to isolate the pathogen were patenting it because they could. And that caused problems. It caused these international disputes. It caused delays in research. And
So that's a public health problem.
Yeah, absolutely. Absolutely. And we didn't see it with SARS-CoV-2 because you could no longer get patents on a viral genome.
Wow.
But
I never even thought about how it would affect non-human genomes. Of course. Yeah.
Yeah. And honestly, that's probably more important these days than, the human variant that, you might find. Because again, the human genome has been pretty well studied at this point. But
we still have more to learn, but we know a lot.
But the basic sequence, we've got a lot of the variants out there. But these pathogens, they're new, right? They're brand new. They are evolving and emerging in real time. We don't know what the next one's going to look like.
No.
And it should be, I firmly believe this should be part of the public domain. And there's still plenty of room for patenting, right? Look, SARS-CoV-2 was not patented yet, Moderna, BioNTech, Pfizer, they've got tons of patents covering their vaccines. They're all fighting each other now in court over their patents, and it'll all shake out in 5 years. But they've got plenty of patents, right? The lipid nanoparticles that are vectors, the spike protein attractors, all of that stuff can get patented. We don't need to patent the naturally occurring viral sequence.
Right. Yeah. And I wanted to ask, we're kind of running out of time, but I did want to ask, a listener submitted a question, Tina, and she wanted to know what your thoughts were on the justification that found DNA in an environment. So thinking like, I leave a movie theater and I take my soda and I throw it in a trash can and I walk away. I'm abandoning this. If that is, if there's a justification that you could come along and bring it to, your genetics person and have that sequenced and learn about me because I've discarded it. It's once something's garbage, it's public property. What are your thoughts on this? How does this work? Am I getting that right?
Yeah, you are. And that sort of gets into the world of privacy law, and sort of tangible property, like physical stuff, which you own, right? You own your body, and you own the saliva, whatever it is that is on the rim of that cup. But you're totally right. You bought the Coke, you bought the cup, you own that cup. But when you throw it away in the trash can, you part with ownership, right? We have this concept of abandonment of property. And so there are a number of cases that revolve around this, like, the famous and infamous case of John Moore, the leukemia patient whose spleen was removed at UCLA, therapeutically, right? This was with his permission.
Right, it wasn't randomly removed.
Yeah,
okay, yes,
he actually was cured.
Sure.
So that's good news. But, but there was something like it was sort of a Henrietta Lacks story. There were some pretty important properties of his cells that UCLA then
yes,
capitalized
now I remember the
on.
case. Yeah.
And, the California Supreme Court held, well, he discarded, that's like abandoned property. You did the stuff that gets taken out of you at the hospital. We consider that abandoned. You part with it, no longer yours. And so UCLA, they could do what they want with it. Now, UCLA did lose that case. They breached fiduciary duties to the guy, and they did get penalized. But as far as the property interest, yeah, it's a really weird area. You do part with that stuff.
It's like when you go get your haircut, do you have to like collect all the hair and leave with it? Like, I don't know. It just gets, it's like Gattaca, right? There's definitely scenes in Gattaca where that plays a huge role of, he's taking like a brush to his keyboard to make sure he's not leaving cells behind. I mean, I feel like more and more we're just going towards a world of Gattaca. But my last quick fire question, Devin, who's a listener and a previous guest on episode 196, wants to know if you have one of your genes have been freed t-shirts after the case is heard by the Supreme Court. It was so funny when she sent me, I'm like, what question is this going to be? Thinking it's going to be like super intellectual. And I'm like, oh, she just wants to know if you have a shirt. Do you own a shirt, George?
I do not. I did not get shirts made up. But now that you mention it,
someone did. I don't know who did. But
I don't have
it's in
such
the
a shirt.
pictures. I'm like, is there a picture in the book? I feel like there might be, because you have some wonderful pictures in the book, which I didn't mention. But yes, but thank you so much for coming on. I mean, this was such a treat to be able, these are, I'm going to be honest for a second. These are like my favorite interviews when I get to read a book, and so many highlights for people watching on YouTube, so many highlights, and it's just like people and concepts and really great ways that you explain and phrase things. And then I actually get to talk to you. So it's fantastic. Thank you so much. And listeners, I want to remind you to head over to our social media. We're at DNA Today Podcast on all platforms and enter our giveaway. You can win one of 5 of these books that we're giving away. And you definitely want to. It's a great read. So thank you so much, George.
Absolutely. And can I just say one last
totally.
plug?
Yes.
If you don't win the free book and you end up buying a copy, half of my proceeds from this book, I'm donating to FORCE, which is Facing Our Risk of Cancer Empowered. It's the support and advocacy group for BRCA positive people. And a lot of the photos in the book are courtesy of them.
Yes.
And they were extremely helpful to me throughout. They've really explained how a lot of these processes and what the people went through, who have these mutations, because patents or not, it's still pretty bad news to get, a positive test here. And so they do great work. And so I just wanted to give a little plug to them.
Yes. Oh, that is so fantastic. Thank you on behalf of the hereditary cancer community for doing that. I think that's just absolutely fantastic. We'll put a link in the show notes to Force and your website and to enter the social media giveaway. So see if you win, and if you don't, then you get to buy the book and support Force while you're at it. Right. So that's pretty fantastic. Well, thank you so much.
My pleasure.
For more information about today's episode, visit dnapodcast.com, where you can also stream all episodes of the show. We encourage your questions, comments, guest pitches, and ideas. Send them all into info@dnapodcast.com. Search DNA Today on Twitter, Instagram, YouTube, Facebook, so you can connect with us there. And a favor, please rate and review the podcast on Apple, Spotify, or wherever you listen. This truly helps us climb the charts and allow more genetic nerds like yourself to find the show. DNA Today is hosted and produced by myself, Keir Deneen. Our social media lead is Corinne Merlino. Our video lead is Amanda Andrioli. Thanks for listening, and join us next time to discover new advances in the world of genetics.
The genes of you and me, the genes of you and me, they're all made of DNA. We're all made of the same chemical DNA. We're all made